Good morning, and thank you for attending today's virtual press conference by the Office of the Judiciary. As you know, we are still in the middle of a pandemic, and so we must proceed in this way. I am the Registrar of the Supreme Court, Camille Darvel Gomez, and I will moderate this morning's proceedings. About 18 months ago, on the 12th of June, 2019, the Honorable Sir Brian M. Murray, QC, was sworn in as Chief Justice. He foreshadowed reform and modernization as a hallmark of his tenure. Indeed, today's press conference bears testament to that promise. I believe that it is the first of its kind in the Office of the Judiciary, and I also believe that it will not be the last. Therefore, without saying any more and stealing the thunder of the Honorable Chief Justice, I call on the Honorable Chief Justice of the Commonwealth of the Bahamas, Sir Brian Murray, QC.
Good morning. Thank you, Madam Registrar. And welcome to all of you to our press conference. Shortly after my appointment as the Chief Justice in June of 2019, I made the following public statement. I said, "It is time to modernize our court system by reform. Major, bold reform. Reform which will overhaul the machinery of justice in the Bahamas. The status quo is not an option. It will not be business as usual. We are now in a new era, one which is time-sensitive, results-oriented, and reform-minded. Change will be the order of the day, focused on modernization, efficient delivery of our services, and adopting best practices applied to courts around the world." End quote. On this basis, last year, I introduced a reform and modernization program for the courts, which is intended to bring the judiciary and our courts into the 21st century in line with best practices. Today, in line with our duty of accountability to the public, I want to provide an interim report on some of the reforms and initiatives which we have introduced, and others which we are working on to transform the court system in the Bahamas. First, I wish to remind all members of the public that a functioning, efficient, fair, and effective court system as part of the overall administration of justice, anchored in the rule of law and based on open access to justice, is essential to the establishment, development, and sustainability of a peaceful, civilized, and cohesive society in a democratic country. Even during these challenging and financially austere times brought in by the COVID-19 pandemic, there should be no doubt by anyone that our democracy is inextricably linked to an independent, impartial, and competent judiciary functioning as a co-equal branch of government within the framework of the Constitution. We must all remember that the judiciary is not a government department or a ministry. It is a separate branch of government, and its independence and overall efficient operation is critical to our free and open society. In this regard, the judiciary must be properly and adequately resourced with funding, infrastructure, staffing, and other necessary amenities to carry out its vital constitutional mandate. The cogency and importance of this self-evident principle is not diminished during difficult times of national crises or emergencies, but rather is accentuated because of the special and critical function of the courts as the ultimate guardian of the Constitution. I am reminded of the words of a judge in another country who said, when addressing budget cuts, and I quote, "When the financial masters are cutting budgets, they should heed the warning of the former chairman of the English bar when he said that we must be careful that we do not end up knowing the price of everything and the value of nothing. During these exceedingly difficult financial times for the country, when tough decisions must be made based on national priorities, I trust that the financial masters will recognize the constitutional imperative to provide the judiciary with adequate resources in order to carry out its role in a 21st century Bahamas, and to adopt what is necessary in order to function in the new normal for the delivery of court services. Secondly, it is important for the public to know that during the period of the public emergency in the Bahamas, dating back to March of this year, the courts have continued to provide essential court services and public access to justice. While court operations were necessarily curtailed at certain times during the public emergency because of safety and public health concerns arising from the pandemic, the courts never closed, and essential services and urgent hearings were never suspended. Thirdly, during the past several months, in line with ongoing developments relating to COVID-19, the Office of the Judiciary has developed and implemented a phased plan for the full resumption of court operations in compliance with public health and safety guidelines. In doing so, we have revised our work processes, introduced new procedures, and substantially expanded the use of remote platforms for court hearings. Some of the specific changes that have been made are as follows. We have automated the procedure for obtaining court hearing dates with the listing office. Secondly, we provided for the e-delivery of court documents for court hearings. Thirdly, we've introduced a duty judge roster for urgent court hearings in all non-criminal divisions. Fourthly, we've introduced the urgent bail application roster in the criminal division. Fifthly, we've established a specific procedure for the hearing of urgent court applications in the criminal division. Sixthly, we posted on the judiciary's website e-forms for the convenience of persons who have cases on the civil side in the Magistrates Court. Next, we've established specialized court divisions in the Supreme Court for family and commercial cases. We've also appointed Judicial Research Council to assist judges in conducting research and preparing judgments and rulings. And we have established the Bahamas Judicial Education Foundation to administer and oversee a structured and comprehensive training program for judicial officers and court staff members. These are all components of the new court system which we are seeking to create in the Bahamas. Now I would like to specifically deal with a few major initiatives which I wish to inform the Bahamian public about. First of all, in line with the new model for the Office of the Judiciary, we have now appointed court administrators who will be responsible for the operations of the courts. This will allow registrars and deputy registrars and assistant registrars to revert to their role of judicial officers, where they will primarily be engaged in hearing interlocutory matters in order to assist with the backlog. I'm pleased today to introduce to you the two new court administrators. First of all, and I would ask her to come up because she is with us this morning, I wish to announce the appointment of Mrs. Constance Delancey as the Senior Court Administrator in the Office of the Judiciary. Mrs. Delancey, I'm pleased to say that Mrs. Delancey has extensive experience as a judicial officer, having served both as a magistrate and as a deputy registrar, and also in the position of acting director of court services. So we're very pleased that Mrs. Delancey has accepted this post, and she will now be the senior administrator in the court system. Thank you very much, Mrs. Delancey. Secondly, I was convinced that in order to implement the changes that are necessary in the Magistrates Court, we needed to have a full-time court administrator dedicated to the Magistrates Court. And in this regard, I'm pleased this morning to announce the appointment of Mrs. Alfonet Grant as the court administrator for the Magistrates Court. Mrs. Grant is with us this morning. Welcome, Mrs. Grant. And I'm pleased to say that Mrs. Grant has extensive experience in the Office of the Auditor General. She's had a wide background. She has many years of administration, and she has already made a major impact on the Magistrates Court since her appointment. So thank you very much, Mrs. Grant, and welcome to the team.
Thank you.
The third appointment which I would wish to announce today is a very important one, having regard to the necessity for our courts to migrate to the delivery of services through a modern technology platform. I became convinced immediately after looking into the matter that the judiciary had to develop some of its own institutional capacity in the area of information and communications technology. And I'm pleased to announce this morning that Mr. D'Amico Isaacs has been appointed as the Director of ICT. Mr. Isaacs is with us this morning. Good morning, Mr. Isaacs.
Good morning. Thank you.
Mr. Isaacs comes to us with wide experience in IT, having worked in the private sector for many years. He has already made his presence known in assisting us with rolling out ICT products and solutions. And together with Mrs. Keva Smith, they will be heading up our new ICT unit. Very good to have you, Mr. Isaacs.
Thank you very much.
Thank you very much, and welcome to our team.
Thank you.
These are important administrative appointments because they will allow us now to develop the institutional capacity within the judiciary in order to implement our reform and modernization program. I would also mention that it is my intention to appoint a court administrator for the northern region, which encompasses Grand Bahama, Abaco, and Bimini. That appointment has not yet been made, although we are considering numerous candidates and expect to fill that position very shortly. I'd like to now report to the Bahamian public on a few specific programs that either will be launched in December or in early January of next year. These programs will all enhance our ability to deliver court services in a modern technological environment. The first one I'd wish to mention is the bail management system. Recently, Parliament enacted an amendment to the Bail Act, which was the enabling legislation for the bail management system. It is now waiting to be gazetted, and we understand that that will happen very shortly. This bail management system will completely automate the process of applying for bail, and it will enhance the disposition of these applications. It'll make it more efficient. It'll make it, certainly the waiting time will be reduced. It'll allow us to keep much better records, to monitor those persons on bail, and it will generally bring a necessary component to our criminal justice system dealing with bail, which is a constitutional issue. We intend to launch the pilot program for the bail management system on the 14th of December of this year, and we will run a parallel system, that is to say the automated system together with the manual system, until the end of January. At that point in time, we will migrate to the bail management system, requiring all applications to be made through that system. This is a significant development, and it actually was started before I was appointed. This project has been worked on for probably 2 years, and so we're very happy to bring it to the finish line and to introduce this ICT solution as we move to upgrade the criminal justice system in our country. The second specific matter which I wish to announce today is the implementation of an integrated court management system. This is a critical component of any court system. And through this case management system, we will be able to deal with the following matters. One, it will allow us to move to an electronic filing system via a secure web portal for all authorized users. This will have a major impact on the way in which we're conducting business at the moment and will affect the registries in a substantial way. Secondly, the case management system will provide an electronic scheduling feature to allow court officers to manage all aspects in the life cycle of a court case. This is critical. You cannot manage what you cannot count. You have to know what your inventory is, and you have to know at what stage all of these cases are in order to case manage them to their conclusion. Thirdly, the case management system will allow us to use electronic notifications and messaging functionality, which will transform the way in which the bar, members of the bar and the lawyers and the public, will communicate with the court and vice versa. It'll substantially reduce the use of paper and emails and will allow us to migrate to an electronic platform for those purposes. Fourthly, the case management system will provide the ability to pay online, to assign fees, and to process payments through the system, which will, I trust, be a major feature for members of the public and will be convenient in order to pay fines and make other payments, filing fees, and other similar matters when using the court system. Next, the case management system will provide an integrated digital recording and transcript software platform, which will be a part of the ICMS. This will now allow us to transcribe our court proceedings electronically and to post these transcripts in the docket file, which is a part of the case management system. This will substantially reduce the waiting time for transcripts and also reduce the reliance on paper and minimize the difficulties associated with locating transcripts across what is, I think, 5 or 6 different buildings which we are operating out of at the moment. The case management system will also provide us with an ability to manage our reporting cycles and to get analytics and other information which is necessary in order to manage our court system. It'll also implement interoperability processes for data sharing between all of the stakeholders in the administration of justice, and it will provide a secure electronic signature feature for user authentication. This is going to be transformative, and the case management system will allow us to launch a whole range of e-services which will fundamentally change the way in which the court is operating. I'm pleased to say that the procurement process has been completed, the successful bidder has been identified, and we are currently waiting for cabinet approval in order to sign the contract and to formally commence that process. And I hope that we will be reporting to you very shortly the finalization of that process, and we will be conducting a virtual signing of the contract. Closely related to the case management system is the court's new digitization project. This project will enhance access to case dockets and records and documents. It'll provide easier data sharing among information systems across the court system. It will improve information management and document handling. It will result in the modernization of the court through digitization and migration of court documents and dockets. It'll provide for the migration of existing electronic files into the integrated case management system. And it will allow us to catalog all of our scanned documents for metadata indexing. This, again, in conjunction with the integrated case management system, will fundamentally change the way in which the courts are conducting business. It will move us from a system which is heavily dependent on paper to a platform where we will be managing data as opposed to paper. This is going to avoid all of the many practical problems we have with the movement of paper files, the management and tracking of paper files, bearing in mind that the courts currently operate out of 5 or 6 different buildings in New Providence. So these are important projects. I'm also pleased to say that we have completed the procurement process for the digitization project, and the successful bidder has been identified. Again, we are only waiting for cabinet approval in order to sign the contract and to formally launch this project. Both the integrated case management system and the digitization project is expected to commence sometime later in December, subject to obtaining the cabinet approval. I also want to briefly mention a new project which will enhance the management of court cases through what is a digital recording system. So we will now move from, in the Magistrates Court, keeping a manual note of the proceedings to a fully automated digital system. And in the Supreme Court, we will continue to use our court reporters in certain types of cases, and then we will supplement that process with a digital recording system. This will allow us to more quickly produce transcripts, and I think will reduce the disposition cycle of cases. It has the potential for reducing a trial by several days based upon all of the data which we have seen. I also want to briefly mention a bill which was tabled in the House of Assembly several weeks ago, which is very important for the court system, and that is the Court Services Bill. This bill is transformative. It will deepen the independence of the judiciary in the Bahamas, and it will deliver a large measure of operational, administrative, and financial autonomy to the judiciary in order to allow us to conduct our own business subject to the oversight of Parliament and the Minister of Finance. I hope that this bill will be dealt with as soon as possible, and it will completely transform the way in which the judiciary is currently operating. Now, there is one other project which I wish to mention, and I'm going to ask the registrar to say a few words on that. And this is what we are calling the Court Automated Payment System in the Magistrates Court. It's known as CAPS, C-A-P-S. The registrar has headed this project, and I wish to publicly acknowledge her incredibly hard work on this and her skill and competence in guiding this process to where we are today. The project is due to be launched later this month, and I would now ask the registrar to tell you a little bit more information about it and why it's so important for those persons who are dealing with the family court in the Magistrates Court. Registrar?
The Court Automated Payment System, CAPS for short, is intended or expected to be rolled out into the Magistrate Court to expand the payment opportunities to our customers of the family court, those making and receiving maintenance payments. The goal of the new system was to provide an electronic payment processing services using multiple payment channels, including mobile phones, the web, walk-in and self-service kiosks, which would reduce and even eliminate the barriers to the delivery and receipt of payments and the subsequent tracking and reconciliation of them. I believe that some of the issues and delays being experienced previously when the Magistrates Court was issuing checks has been reduced by the implementation of the direct deposit system. However, with the introduction of caps, this system is another opportunity for our customers to receive their court-ordered payments. The use of caps would be a welcome benefit to those customers who may not have a bank account or who may wish to have the convenience of being able to receive and access their funds almost simultaneously once the payments are made. Customers signing up to use caps would not only make payments at the magistrate court, but they will be able to make payments using self-service kiosks located throughout New Providence. They will be able to access caps online and make payments through an online web interface. And they will also be able to make payments using their cell phones using an app. These additional payment options will dramatically reduce the need for anyone to come and attend at the magistrate court and makes it more convenient for the person making and receiving the payment. Additionally, and more importantly, as soon as the payment is made, an electronic notification, which serves as an electronic record, is sent to the person receiving the payment, the beneficiary, as well as the person making the payment. And the beneficiary is able to either spend the money as digital currency, or they can receive the funds in cash by withdrawing the funds from an agent location. There are several agent locations in New Providence and the Family Islands. Therefore, we are very pleased with the pending introduction of caps at the Magistrate Court, specifically in the Family Court. And this is a very significant step for the court as a whole and moves us in the direction of modernization, digitization as expressed by the Chief Justice, and also sets us on a trajectory of a more customer-centric focus. Thank you.
Thank you very much, Registrar. I hope that through this brief interim report this morning, you will see that we have been working very hard in the judiciary in order to deliver to the Bahamian people and all persons in our country the type of court system which is becoming of a 21st century Bahamas. All of these projects are very practical. And you will see that they will have a direct impact upon efficiency, upon convenience, and upon the time that it takes in order to get a case through our court system. I would like to just give you a short update on where we are in resumption of court operations. And let me start with the Court of Appeal. Under the able leadership of the President, Sir Michael Barnett, the Court of Appeal is fully functional and is hearing all cases by virtue of their remote platform. With regard to the Supreme Court, let me deal with the Criminals Division first. We are now hearing all types of applications on the criminal side of the Supreme Court. I'm pleased to say that last week, we resumed criminal jury trials, and we conducted our first 2 criminal jury trials last week, and I think one of them is continuing into this week. The volume of cases that we are hearing, of course, still is significantly reduced. We're not able, given the constraints of the physical space that is available to us, to operate 7 or 8 courts at the same time. But we are intending to operate 4 criminal courts at the same time in a way which is consistent with all of the public health and safety protocols and requirements. There's been a lot of planning that has gone into the resumption of criminal jury trials in order to ensure that all users, our judicial officers, our court staff, the jurors, the members of the bar, the public, that everybody is provided a safe environment in compliance with the physical distancing requirements and the other public health directives. That is a major accomplishment because there are many countries in the region who have not yet resumed criminal jury trials. And so I was very pleased that we could start these trials after many months of having had to have suspended them. All other types of criminal cases are being heard. Hearings on bail are back to more or less our normal position. All urgent bail applications are being heard usually within 24 hours, and if not, certainly within 48 hours. All other bail applications are heard within a period of I'm told, 7 or 8 working days. We are hearing case management applications. We are dealing now with VBIs, voluntary bills of indictment, which was suspended for many months, but I'm pleased to say that I resumed our procedures for VBI matters a week ago, so all those matters are now being dealt with. And subject to getting back to our normal volume, our criminal courts are now fully functional in the Supreme Court. Staying with the Supreme Court for a moment on the non-criminal side, that is the civil, commercial, family, and other divisions, all applications and trials now are being heard. All interlocutory applications, all urgent ex parte applications are being heard. The family court is fully operational, and we are conducting civil and commercial trials by remote. And on occasion, we have done some in-person trials subject to the strict compliance with the health requirements. And so at the level of the Supreme Court, while the volume of our work is still somewhat reduced to what it was pre-COVID-19, we have now resumed all operations. Now let me briefly deal with the Magistrates Court. That has been challenging for us. That is a different court. The volume is very high. There are many, many parties, defendants, accused persons before the magistrates' courts who are not represented. And so we've had to face certain challenges there which have delayed us from reintroducing all criminal trials. But here is where we are in the magistrates' court side. We are hearing remands, and we never stopped hearing remands. We are hearing arraignments and first pleas, and we never stopped hearing those. We are now hearing urgent civil matters, which are certified by the Chief Magistrate or the Deputy Chief Magistrate. And we are hearing urgent family matters. We have not yet been able to resume normal civil trials and criminal trials. Although our plan is in place, that has been worked on by the registrar, and since her arrival, Mrs. Grant, we have our plan, which is fully in place. The only thing we're waiting for now is the installation of the plexiglass barriers in the magistrates' court in order to resume civil trials, family trials, and criminal trials in the magistrates' court. So on that basis, I think we are doing quite well. In conclusion, before we take your questions, I would just like to acknowledge and thank the Attorney General and persons in his office for the assistance which they have given to the judiciary in dealing with these matters. I'd also like to recognize and thank the Minister of National Security and his Permanent Secretary, P.S. Roll, for their assistance in dealing with the IDB-related issues. That involves the Integrated Case Management System and our digitization project. These are very good examples in difficult times of proper and responsible cooperation between the different arms and branches of government, which will be necessary in order for us to fulfill our mandate. On that basis, I would now turn it over to the registrar to moderate any questions that we may have from the members of the press.
Good morning. Are there any questions?
Hi, good morning. Leo Seeley from Eyewitness News. My first of two questions. I noticed that there has been a lot of talk about the rollout of the online payment for family court matters. What plans do you have in the pipeline for the same to be done for paying fines at the court? Could we see that being rolled out in the near future where it's all online?
See, the short answer is yes, that is the intention. This is the beginning of the rollout of online payments, and so the short answer is that is the intention. That is where we're headed.
Any timeline on that? That's not my second question, but just for, I guess, expansion on that idea, any timeline on when fines could be seen to be paid online?
I'm going to defer to the Chief Justice. Hold for me.
Yes, thank you, Registrar. With regard to the Magistrates Court, the timeline is looking like sometime during the second quarter of 2021. We are hopeful that we might be able to accelerate that to perhaps March, but I think reliably we can say in the second quarter. With regard to the e-payment platform in the Supreme Court, that's a part of the integrated case management services that will come online, and we expect that, again, that's targeted for the second quarter of next year. Registrar?
Mr. Seeley, was that your two questions? You, okay. Mr. Seeley?
And my second question, I know that the Chief Justice has spoke about a lot about reforming the judicial system, bringing some order to processes and human resources. We know that there was an incident that happened previously that was under investigation, where it was a pre-independence party in the courtroom. Can we get an update on what was the findings of that investigation and what rules have been put in place to ensure that something like this does not happen again?
Okay. To Chief Justice?
Yes, we did conduct an inquiry into that matter from the point of view of our court staff. The issues relating to the police were, of course, dealt with by the Commissioner of Police. We made certain conclusions and identified the causes for that incident, and appropriate disciplinary proceedings or action was taken. The new protocols that we have put in place strictly prohibits the use of courtrooms or indeed any rooms or offices in the Magistrates Court for public events or social events without following now a designated procedure, which involves an application, involves the approval, it involves appointing a senior court officer to preside over those proceedings, and it also involves oversight to ensure adherence with strict physical distancing requirements. So we do not expect a reoccurrence of that event, and Mrs. Grant, our new court administrator in the Magistrates Court, is fully engaged in that regard, and I don't think the public will see that happening again.
Okay. Thank you, Mr. Seeley from Eyewitness News. I believe there's a question from Mr. Higgs from our news. Mr. Higgs, Jared Higgs.
Hello, good morning.
Good morning.
So my question is for the Chief Justice. So last week, as a result of a constitutional application filed by her lawyer, a stay was granted to a woman who waited 11 years to be tried for murder. The family of the victim in that matter are angry that nobody has been tried after all these years. There are two other people who were accused. They did not make any applications for a stay, so I believe they're still awaiting trial. But in any event, a defense attorney, first, can I get the Chief Justice to respond maybe to the family's concerns that justice in this country is difficult to come by?
Hold on for me. Chief Justice.
Yes, well, I'm not aware of the details of that case, and of course, it wouldn't be appropriate for me to comment on those details. But what I would wish to assure the family of, and indeed all members of the public, is that access to justice is an important and essential part of the court system in any democratic country. The constitutional motion which has been filed will be dealt with in accordance with our procedures. By virtue of the nature of constitutional motions, they are given expedited attention by the court. That is the case with all constitutional applications. And the matter will be dealt with. The presiding judicial officer will consider the issues, and I trust that the family will see that our court system works as it should within the context of the constitutional application. The underlying facts concerning the period of remand, as I said, I'm not aware of them, and in view of the fact that that's a pending action, it would not be appropriate for me to comment on that anyway. But I would wish to ensure everyone that we are fully engaged in trying to address the remand periods for all accused persons who are in the criminal justice system. I might add that that's a problem which faces every court system in the world. That doesn't mean, of course, that we don't have to address it ourselves in a proper and fair way to all parties. I just want to put a little perspective into this issue. Periods of remand should, of course, be under review. And so persons who are on remand should have their cases reviewed. Under our system, persons on remand are required to be brought before a judicial officer, usually a magistrate, every 7 days. And that happens. We are conducting remand hearings every day of the week. And that is one of the types of hearings that I indicated earlier was never suspended, even in the height of the first phase of the pandemic. So our remands have continued throughout, and they will continue. And we will bring enhanced focus on trying to monitor the remand periods. But the family can expect justice in accordance with our system with regard to their constitutional case, and we'll have to see what happens in that regard.
Mr. Higgs, you have your second question.
I'll use my second question to kind of expand a bit on the first one to clarify the situation, then ask that follow-up question or that second question. So, as a matter of fact, the woman who filed the constitutional application was successful. So she had her matter stayed. So it's really the family of the victim in the case, the person who was murdered, who I'm referring to, who expressed concerns about justice in the country. The murder happened in 2009, and nobody has been tried for it as yet. So I'm talking about the length of time that it takes for a matter to get to trial, even, or some matters, I should say, because some matters come more quickly than others. A defense attorney, in any event involved with that case, has suggested that prosecutors use more plea bargaining to move some cases along. She suggests that prosecutors are reluctant to do so. Chief Justice, can you say whether you would recommend to prosecutors, given the backlog that we're talking about here, with some cases being as long as 11 years, what types of solutions are there really to resolve those really long-standing cases?
Oh, yes. Well, thank you for that clarification. We must differentiate between the functions of the law enforcement agencies in investigating and charging persons. That has nothing to do with the courts. And then the role of the Director of Public Prosecutions, who is the prosecutorial agency in our criminal justice system. And again, that's quite separate and outside the judiciary. And then we have the third component, which is the judiciary. Once the case has been investigated, once somebody has been charged, once the DPP has commenced the prosecution, then it becomes a matter for the courts in order to deal with it. I welcome your question with regard to plea bargaining, because it must be an integral part of any modern criminal justice system. And I would strongly encourage a more robust approach to plea bargaining by both the DPP's office and the defense bar, the private defense bar. Because what the empirical data shows throughout courts around the world, that no court system in the United States, in Australia, in Britain, in the largest countries in the world, no court system has the resources to bring to trial every criminal case that is filed. It simply cannot happen, and it doesn't happen anywhere in the world. So plea bargaining becomes an integral part of the disposition regime for criminal cases. And in the Bahamas, our rate of plea bargaining was really quite low. Recently, and by recently I mean probably within the last 3 to 5 years, we have seen an increase in cases being plea bargained, and that is encouraging. But I would strongly support the judicious and careful and proper use of plea bargaining in appropriate cases in order to mitigate the backlog. And as I've said, it has to be an integral part of the system, because we cannot take all criminal cases to trial. We just don't have the resources. So I'm glad that the DPP seems to be focusing on that. I hope that the members of the private criminal bar will also focus on it, and that we will see an increased use of plea bargaining as we move forward as a part of our backlog reduction program.
Tyler Simonet from JCN, do you have a question?
Yes, ma'am. Good morning to everyone. I just wanted to know if we could get a number of how many workers in the judicial system have tested positive for COVID-19 or have had to go into quarantine.
Chief Justice. Hold on.
I'm afraid I don't have those statistics to hand. That we'd have to check with our human resources unit and department to get that. You've asked, I think, two questions there. One is how many staff members have tested positive, and the other is how many have been put into quarantine. Those, as you appreciate, are quite different questions. Many persons are put into quarantine who actually never test positive, but because they've come into close proximity with someone who may have tested positive. So excuse me, I'm afraid we don't have those statistics today. Our HR department would have those statistics, and we would have to look at them for you.
Ms. Simonet, do you have a second question?
Yes, I do. Thank you for that response. When it comes to the Bail Amendment Act that gives magistrates the power to grant bail in emergency cases, could you tell us exactly what would constitute as an emergency, and how often would you expect magistrates to use this power?
Oh, Chief Justice.
Well, currently, the jurisdiction of magistrates to grant bail is very limited because of an amendment which occurred several years ago. Now, I am pleased to say that in the recent bill to amend the Bail Act, which I referred to earlier, which was passed by Parliament a week or so ago and is waiting to be gazetted, it does include provisions which return to the magistrates jurisdiction to grant bail in a whole range of serious criminal matters. That is, in my view, that is a welcome development. I don't see any reason why the magistrates should not have the jurisdiction to grant bail in these matters. And I think that is going to significantly address some of the concerns which have arisen as a result of the rollback of the jurisdiction for magistrates to grant bail. we've had a lot of cases where there have been unintended consequences, where persons are charged before the magistrate, they plead not guilty. Under the current legislation, before the new act is gazetted, the magistrate would not have the jurisdiction to grant bail, and so the magistrate has to remand that person because that person now has to apply to the Supreme Court for bail. In many cases where the bail application would not even be opposed by the DPP, and in other cases where it would be highly likely that bail would be granted. But because of the logistics of moving from the Magistrates Court to the Supreme Court and filing your papers and getting before one of our judges, that has resulted in persons remaining in remand when otherwise they could have made their bail application to the magistrate at the first plea, and the magistrate would then have made a determination as to whether to grant bail or not. So I think this is a very positive development, and the return to the magistrates of the jurisdiction to grant bail in many of these cases, I think will substantially diminish the concerns that we've had with regard to people being on remand before their bail application is heard.
Royston Jones from Eyewitness Digital. Sasha Lightburn from RTV, do you have a question?
Yes, good morning to all those who are present. My first question is for you, Madam Registrar, or even the Chief Justice himself. Do we have the current figure for the backlog of cases in both the Magistrates Court and Supreme Court system?
We don't. We don't have those figures, unfortunately.
Okay, I'll go to my next question. What is the figure on the digitization process for the court system on both sides, the Magistrates Court side as well as the Supreme Court side, the dollar amount, that is?
I'm not sure I understand your question. The dollar amount of files, I'm not sure.
No, the dollar amount, the number that it's costing to upgrade the court system by digitizing most of the processes within the system.
I'll defer.
I'm not sure I want to preempt Cabinet by providing you with that information at this time. What I can say, and I don't want to be evasive, it's a proper and reasonable question, and of course we in the judiciary acknowledge that we are accountable for the use and expenditure of public funds. So I think it's a very fair question. But I don't want to preempt Cabinet on this. What I can say to you is that if the Cabinet approval is obtained, we will have a virtual press conference when the contract for both the case management system and the digitization project will be signed. And at that time, the amount and the costs of both projects will be made available to the press. But I think for the moment, I should respect the process and wait for Cabinet to deliberate on these matters before we get into those details.
Krishna Russell from the Tribune, do you have any questions?
Yes, good morning. My first question is, so ultimately, when can we expect the full digitization and upgrade of the court system to be complete?
12 months.
Okay. And my second question is, what can officials say about the integrity of the courts? We know earlier this year there was an Auditor General's report concerning alleged impropriety of cashiers who were receiving payment. And I know that you guys have implemented a series of changes, but a lot of the public, still questions the integrity of the system.
I'll defer to the Chief Justice.
The integrity of the court system and the administration of justice is essential in order to earn the public confidence in our court system. And so this is a matter which is extremely important. The issues that arose as a result of the report of the Auditor General in the Magistrates Court have been partially addressed with regard to changes in processes and procedures and checks and balances and different protocols. And I must say that there are the final response, the final chapter of the response to that report will be introduced probably before the end of December, or if not in early January, which will involve a substantial revamping of work processes in the Magistrates Court. I might say that Mrs. Grant is especially qualified to oversee these initiatives, given her auditor's background, and we are placing a high emphasis on this. So I can assure the Bahamian public that these issues of integrity and honesty and transparency and the way in which we deal with money and the disposition of cases, and I might add, the whole regime dealing with alternative sentencing, which does not involve a custodial sentence but may involve some form of counseling or some other type of sentence other than incarceration. All of that is being revamped. I am working with the Ministry of Social Services and one of their key departments to introduce new procedures and protocols for oversight of all agencies who are involved in non-custodial sentencing. I had a very productive and helpful discussion with the Minister of Social Services about a week and a half ago, and he is fully supportive of our efforts to revamp this procedure, to make it more transparent, and to bring it in line with best practices. So we have already addressed many of those issues. We are addressing those issues, and there will be major changes in our work processes and procedures to ensure accountability, transparency, and by the way, it will also involve improving our service platform for users of the Magistrates Court.
Royston Jones from Eyewitness Digital.
Good afternoon. A question about given the level of overcrowding of the Department of Correctional Services, notwithstanding some early release exercises in recent months, can the Chief Justice shed some light on the course use perhaps of suspension or deferment of sentences during the pandemic, if it was used, and to what extent? I know there's a technical term for that, but in the general sense.
I can respond in this way. The judiciary is of course aware of the overcrowding issues at BDOCS, at the Bahamas Department of Correctional Services. Now, sentencing is a matter which is fact sensitive in specific cases, and of course that is a matter within the exclusive domain and discretion of the presiding magistrate or judge. So we do not trespass into the exercise of that discretion. But as a general policy, we certainly were aware of this problem, and we were careful not to impose a custodial sentence unless it was thought to be absolutely necessary in the case. So I don't think there was any formal protocol put in place, because, as I said, we don't want to fetter the discretion of a judicial officer when deciding issues relating to sentencing. But there certainly was an acknowledgement and I think an intention to avoid custodial sentences unless it was thought to be absolutely necessary. Now, in the serious cases, this is not an issue, it's clear. The gray area is in those less serious cases where perhaps a fine or some other non-custodial sentence is an option. And in those cases, I think we tried to avoid incarceration whenever that was possible.
Do you have a second question, Mr. Jones?
Thank you kindly. The second question is there, I believe my system froze earlier when Sasha may have asked about the backlog of cases, but if it hasn't been asked, I would like to ask about the backlog of cases perhaps, as well as if it's known and can be presented the conviction rate of cases perhaps for 2019 or statistics for this year, and whether there's a goal in mind of the number of cases to be heard with all the challenges presented this year, whether there's a goal in mind for the number of cases to be heard this year and in future years.
Well, unfortunately, we do not have a statistical unit within the court system at the moment, and I don't think we ever have had one. So the compilation of statistics and empirical data is somewhat limited. This information is probably available, but it's not readily accessible because one, we have minimal computerization and technology in our system, which I'm trying to change, and we're making good progress. And secondly, we have no statistical unit because we haven't had the resources to staff such a unit up to this point. Rates of conviction and prosecution, of course, are more appropriate to be monitored by someone else. But certainly, what I call the disposition cycle of cases in all divisions of the court is very important. And that is a statistic which I am trying to obtain. And if we are able to set up a small statistical unit, we will certainly be able to provide this information in a better form than I can at the moment. I am focused on backlog reduction, and I am focused on the reduction of the disposition cycle of cases on the criminal side and the non-criminal side. Now, the factors which affect the disposition of a case are literally scores of different factors, ranging from systems to processes to behavior, to lawyers, to procedures, to all the stakeholders. So it isn't an easy question. But certainly to be able to monitor our disposition cycle, to be able to monitor what's going on in the life of a case is precisely what the integrated case management system is going to bring to the court. And that is why, that's only one of the reasons why it's so important. It will improve our ability to track and monitor the life of a case from start to finish. It'll also provide, with the press of a button, a whole range of analytics, which will be useful to our administrators as we try to better manage the court system. So these are all issues which are in play. I just mentioned one other thing. Every year the judiciary produces an annual report, which we're actually working on now. And you will find, if you go back to these annual reports to 2019 and 18 and 17 and previous years, there are a lot of statistics in that report dealing with registrars, magistrates, Supreme Court judges, and you will find perhaps some of the statistics that you're looking for. They deal with numbers of cases, disposition of cases, types of cases. So I would commend to you and other members of the public who are interested to get the last report, which is the 2019 report, and we will be publishing the 2020 report in early January. And you will find some statistical data in those reports.
Fern Carey from ZNS News. Ms. Carey, are you there? Do you have any questions? Okay, well, that ends our press conference, and I would now invite the Chief Justice to say some final words. Thank you.
Thank you, Registrar. I just wanted to close by acknowledging the very considerable efforts and work of the staff of the judiciary. We have a significant cadre of persons working within the judiciary and within our court system. I have brought to the courts an aggressive and ambitious program, and it can only succeed, and we have only had the success that we've had to date because of the quality of our people and our staff, and because of the hard work which they are putting in to reforming our court system. So I would like to publicly acknowledge their contribution. We have with us this morning the head of our marshal unit, Mr. Zonical. Mrs. Zonical, you want to come up for a moment? The marshals are an important part of our staff. They control security. Mr. Zonical, just come in for a moment. I would just wish to thank you and your unit for all of the work that you've done for us in getting our criminal trials back on track and our civil trials. We needed the assistance of the Marshals Unit. We wouldn't have been able to do it without you. So thank you very much, and keep up the good work.
Thank you, sir. You're welcome.
And I say publicly a very sincere and profound thank you and word of appreciation to all of the members of the staff, to our supervisors, to our judicial officers, and to everyone who's joining me in this mission to give the Bahamas the type of judiciary and court system which it deserves, given its status in the international community. Thank you very much, and I wish you all a good day.
Thank you very much, Your Honorable Chief Justice. We would like to end by indicating that we have a website, bahamasjudiciary.com, and you can also find us on Facebook and Twitter, again, Bahamas Judiciary. And I would like to finally thank the press for participating in today's press conference, and also the hardworking team at Bahamas Information Services who made this virtual press conference a reality. And thank you to all, and continue to be safe.